Welcome to our YouTube series on employment law, focusing on employee terminations. My name is Christopher Neufeld of Neufeld Legal. And in this particular video, we'll be discussing the power position that employers tend to utilize to the disadvantage of most employees, both during the course of their employment and when they are terminated, let go, fired, or quit their job, and how this impacts adversely the employee's ability to get what they are rightfully deserving of. Now, in most employment termination situations and employment arrangements, employees find themselves always at the mercy of their boss. And why are they at the mercy of the boss? Well, firstly, the continuance of their employment is dictated on the employer continuing to employ them. There are provisions provided by law, yes, protect the employee somewhat, but also allow the employer to terminate an employee without cause and simply pay them out a sum of money. And although employers don't necessarily like to pay out those sums of money, they can do so if they feel that their authority is being challenged, or if they feel that there's going to be a problem going forward. So, employees find themselves at the discretion of the employer. Similarly, when they're finally terminated, now an employee is without a source of income. They have to find replacement income, and they're oftentimes not anticipating this and haven't saved up enough to pay and keep their livelihood. So what is the situation for the employee at that time? A very difficult one, because now they're cash strapped unexpectedly oftentimes, and they find themselves going against their former employer, who has continued to operate their business and has money available to them to protect their legal position. And it's not only their legal position as it relates to that particular employee, it oftentimes is also a necessity to protect their legal position relative to all their other employees. And because of that, the employer is sort of forced to take a very hard position, especially when it comes to giving out more than what they would otherwise be paying out. Because once they set a trend, the very likelihood is that they will be forced to continue to pay that kind of money out. And if they can use their power position to their advantage, most employers are going to take advantage of their power position to push back as against their employees. And that is problematic for them, because whereas the employee is now in a difficult position of trying to find new employment, the employer possibly has achieved cost savings by having relinquished that employee and putting the burden of their work on their other employees, so they are thereby saving money. But they are also, in effect, setting a position relative to those other employees to keep the costs down. And this means that they take on the role of using corporate money to fight against any challenge. And because most challenges are individualized, the employers know that they can push back, let the lawyers deal with it, and eventually they'll have a result that is the same now as it could very well be later down the road. And therefore, it is to their advantage to draw out the process, to make it lengthy, time-consuming, and expensive for their former employee. And it doesn't really make a difference to them, because the company is still operating and it's still drawing in money, on top of the fact that this is a natural cost of doing business. And they realize that most employment lawyers take a very individualized approach to dealing with legal matters. They're focused solely on the individual, and this is detrimental to their strategy. It is something that we try not to do, at least myself, I try not to do, because focusing too much on the individual loses one's power position. And when you give up a powerful power position, you're going to find yourself in a very challenging and detrimental position to effectuating the best strategy for one's client. However, it appears that a lot of employment lawyers don't fully appreciate that. And this can be due in large part to the fact that in certain jurisdictions, there is minimal advantage in looking beyond the individual position. You have to be in the right jurisdiction, that means in the right province oftentimes, to be able to take a broader, more expansive approach to how you deal with employment litigation. So you might not be able to have this happen in a province, say, as Ontario so much as you would have in the province of Alberta. Similarly, differences between countries, differences between laws. You might be able to have a better perspective in an employee-friendly province or state, such as California or even New York State, as compared to states like Florida and Texas, or Alabama, or Georgia. It really depends on the specific laws and what the lawyer can do in that particular jurisdiction. And this creates its own fundamental issues. And unless you understand it and your lawyer understands it, you can find yourself at a natural position of weakness and lacking the ability to challenge effectively from a legal standpoint your employer as much as other employees are in other jurisdictions, whether it's another state or it's another province. And that creates its own series of issues for employees. Nevertheless, what you need to be doing is trying to reassess and try to redetermine where your power position might lie and how to strengthen your own power position so as to move forward. Because so much depends on rebalancing the power position, reassessing the power position, understanding it, working with it, and then taking advantage of it. Because when you allow the power position to just overwhelm you, you're not going to be in a position to tackle things. And the power position is going to continue to persist almost always during the course of your employment. So you're going to have to, in effect, load up from your employment. And if you still are employed and you're listening to this video, what your job is really to do is to recognize that in certain jurisdictions, you're going to have an opportunity when you quit, when you get terminated or fired, to collect on the underpayments, the situation that you have with your current employer. You're not going to really jeopardize your employment to realize upon those underpayments unless you're necessitated by financial necessity. So instead, what you do is you sort of keep those chits, keep those tokens in many respects, and you parlay them and take them out later on in the process when you actually leave your job, whether it's voluntarily by quitting or it's involuntarily when your employer terminates you, fires you, dismisses you, or whatever the termination term might be. Then you recoup on what is underpaid. You collect on the money that is owed. But you have to play it smart and you have to play it correctly. And you have to collect the information that's necessary and is required to then go back to your employer with the knowledge that you have, the information you have, and the right legal counsel. Because then you are rebalancing the power position that you otherwise find yourself in, and you collect on the monies that are owed to yourself. because when you earn money, and it's earned as a result of legal provisions set down by statute, it is your money. The fact that it has not been paid does not mean it has not been earned. In all likelihood, it has been legally earned, and oftentimes the statute even provides that the money is held in trust for you for your benefit, and it is not reverting back to your employer. Employers don't want to accept this or see this because rarely are they challenged on it. But the fact of the matter is, if you've earned money and it's simply not been paid, you can eventually go back and collect it. The obligation is on you, though, when you're currently working, to make sure you properly record it, you put it down to paper, you even speak with a lawyer early in the process when you identify something like this to make sure that you're correct in your processes and that you're collecting the right information and you're booking it away properly. And you take steps to ensure that when the time comes, you're able to attain that money. It might be indiscreet communications with respect to your employer. It might be just keeping it totally on the silent until the time comes that you need to collect on that money and you are out of a job. But it's something that does exist. A lot of it depends on where you work. But if you're entitled to it by the law of the land, being the state or province within which you're working, just make sure you're keeping a record of it. Make sure you're keeping the records that are provided from your employer. Everything that your employer provides. And oftentimes a lot of this stuff is emailed to you on the company email. So you need to either print this information out and keep it at home or email it to your personal email accounts. Because when you're terminated, fired, or quit, those email accounts with the company are quickly shut down and you lose access to them. And then you're out of luck with respect to getting access, and you have to oftentimes go through certain hoops and hurdles to regain access, because it's to the employer's advantage to deny you access to this information, even though you were entitled to it months in advance. So what you need to do, make a move, protect yourself, and make sure you collect upon the money that you've earned and reassert the position that you had with respect to the power position that employers take advantage of and you find yourself in. And that is how you better position yourself going forward and you get all that you have earned. You're not necessarily going to get it all when you're working, because that could jeopardize your continued employment. But you got to save up, collect, know where the underpayments are, have proper records, often take early legal guidance, and then when time comes, make a move to collect upon it, because it's money that's due to yourself and it's money that you need to collect on. Thank you.